and good morning or afternoon, depending on where you're watching. We want to start today's panel on the litigation over Wisconsin's spring 2020 election. My name's Atiba Ellis. I am a professor of law at Marquette University Law School, and I teach election law, civil rights law, constitutional law related topics. And I'm the moderator for today's panel. I want to talk about—
Hey, are you starting this, or I'm not responsible for starting this, am I?
No. We're live, Craig, and I'm going to go ahead
I've got to jump as soon as you all get online going.
Yeah, welcome to Zoom land, everyone. So I'm starting off right now. Craig, I will ask you in a second to mention the chapters that are organizing this, and then we'll go into the substance of our panel, and I'll introduce our panelists, we'll let them talk, and then we'll have Q&A at the end. So, Craig, if you want to talk about the organization for just a second.
Jake is in charge of all the technical stuff.
All right, I'll start to connect with him. Thanks.
Thanks.
Hey, Craig, this is Jake at ACS. You're live if you want to give us a brief overview of ACS and maybe the work that the Wisconsin chapters are doing between Madison and Milwaukee and all the law schools.
And in particular, organizing this panel today. Okay, so I'll just go ahead and do that then. I'll just mention that the ACS Madison chapter and the ACS Milwaukee chapter are the chapters that have organized us today and brought us all together. They have asked the panelists, and certainly the chapter leaders are involved in this and other ACS related information. And we'll mention some of the further events regarding the Wisconsin litigation at the end of our discussion today. So let's get to the main event, folks. Let's introduce our panelists and then let them talk. Each of them is going to talk for about 10 minutes regarding the litigation that they are involved in and their insights about what is going to go forward in this and the impact. After that, we're going to do Q&A. And let me just say now, as they're talking, all of you out there who are connected via Zoom can use the Q&A button, which should be in your Zoom window. It may be at the top of the window or at the bottom, but you can ask questions via that window. And once all the panelists have talked, we'll turn to that Q&A queue. If you are still formulating questions, I may ask questions of the panel, but our hope is that half of our conversation will be our litigators and then half will be discussion. So let me first, and I will introduce our folks in the order they're going to go. First, Sopan Shah, who is an associate at Perkins Coie LLC, and who is one of the plaintiffs' counsel in Democratic National Committee versus Bostelman, which was filed in the Eastern District of Wisconsin. And she is a member of the ACS Madison Lawyer Chapter Board of Directors. Second, Doug Poland, who is a member at Rathje Woodward LLC, and who is plaintiffs' counsel in Lewis versus Knudson and Gear versus Knudson. And third, and I should mention, he is also a member of the Madison Lawyer Chapter Board of Directors. And then third, Stacie Rosenzweig, who is a partner at Hailing and Cayo SC, and one of the plaintiffs' counsel in Edwards versus Voss. Now, these three cases are only representative of the over eight cases that have been filed in both the federal courts and the state courts around the Wisconsin election. And the heart of the issue is that the legislature decided to go forward with the election despite the COVID-19 pandemic. I'll leave it to our speakers to fill in the details, but I'm sure we're all familiar, so we can just get right to our speakers and letting them discuss their particular litigation. So, Sopen, I'll turn it over to you.
Thank you, Professor Ellis, and thank you to ACS Madison and all the attendees for being interested in this litigation and the issues. So we filed the first lawsuit about the April 7th primary election in Wisconsin around March 18th. And that was sort of the time that, you know, we realized that this COVID-19 pandemic was very serious, and that conducting the election as under existing law would pose some serious health risks and pose risks that the election would be unfair, right? So we filed this lawsuit in the Western District, and we challenged multiple provisions of Wisconsin law. And the first relief that we got was the district court extended the online registration deadline, which was set for March 18th. The court extended it to March 30th, recognizing that more people would want to register to vote online as a result of the pandemic. And, you know, the court suggested that we could move for a preliminary injunction on some of the other requested relief. So we spent a week interviewing Wisconsin voters who felt that those provisions would prevent them from voting. And we also spoke with a number of local officials whose offices had been dealing with calls from voters and unprecedented numbers of absentee ballot requests. And we put all of that evidence in front of the district court. And after an evidentiary hearing, we received partial relief. So the provisions that we received relief on, so we got an extension of the election day ballot receipt deadline from election day until April 13th at 4 p.m. And based on the numbers that we've seen, you know, between 90 to 100,000 Wisconsinites were able to cast their votes because of that relief. The other piece of relief we received was the extension, a brief extension of the deadline to request an absentee ballot, and the relief from the witness requirement for those who would attest that they could not safely obtain a witness with reasonable effort. So, you know, one of the members of the 600,000 Wisconsin households that have only one person, the elderly who would feel that exposing themselves to someone else would increase the risk that they would contract COVID-19. So this, as I'm sure many of you know, this ruling was immediately appealed to the Seventh Circuit, and the Seventh Circuit narrowed the relief that the district court gave by staying the enforcement of the witness-related relief. So the Seventh Circuit said the district court's order was overbroad, and therefore, you know, the witness requirement would still apply to the April 7th election. And then, you know, that ruling was, of course, appealed, and the Supreme Court, in an opinion that has received a lot of media attention and commentary, imposed a postmark deadline for the absentee ballots. So ballots received by April 13th at 4 p.m. would count, but only if they had been postmarked by April 7th on election day. And, you know, there are a couple of things to say about that Supreme Court opinion. One fact that has received a lot of attention is the court really, the majority opinion, so it was a 5-4 opinion, split along partisan lines effectively, and the majority made a big deal out of the fact that the plaintiffs had never requested the relief at issue, that we had never asked for ballots postmarked after April 7th to count. And the dissent pointed out that during this evidentiary hearing that I mentioned, we explicitly asked for that relief. And, you know, the court also speculated about some things that might happen if ballots postmarked after Election Day were allowed to count. The court speculated that results might leak despite the district court's gag order preventing the release of results. And, you know, the majority thought, oh, this extension of the postmark deadline that doesn't exist in Wisconsin law would change the nature of the election. And as we saw after April 7th, you know, the release of results did not occur. And so that prediction, to the extent that it was in the Supreme Court's decision and influenced their thinking, was incorrect. And of course, Justice Ginsburg wrote a dissent that sort of makes at least one of the points that I just made. And certainly, you know, Professor Ellis asked what our sort of takeaways or lessons learned from the litigation would be. And certainly one thing that I keep thinking about is that this US Supreme Court opinion deserves a prominent place in a longer conversation about the institutional legitimacy of the court. But I would say that a silver lining, which I think as we approach the fall election is going to make a big difference of the court's decision, is that the court approved extending the ballot receipt deadline past Election Day. So I think we might see that become important in the future.
Okay. Doug?
Well, thank you, Professor Ellis, and thanks, Sopen and Stacie, for being here, and welcome everyone up into my the third floor of my house where my family has now exiled me. I've got kids who are in college who are back home and are filling up the downstairs and don't want to hear me talk anymore. So here I am with dollhouses in the background and everything. I was, as Professor Ellis mentioned in the beginning, I'm counsel to two of the plaintiff groups. There are three cases that have been consolidated within the Western District of Wisconsin for the purpose of litigating the election issues, and I'm counsel to two of them. One of them, Geer versus Knudson, was filed, I think it was about 10 days after Sopen and her team filed the initial complaint. I am local counsel, Wisconsin counsel in that case, along with lawyers at the Fair Elections Center in Washington, D.C. That case takes a slightly narrower view in terms of its claims and the relief that it seeks. That was primarily directed at the witness requirement that Sopen mentioned. As she noted, there is this requirement for mail-in absentee votes, that they have to be witnessed by an adult. It doesn't have to be a registered voter, but it does have to be an adult. There was evidence that we presented at a hearing that was conducted on April 1st. And by the way, just an aside about that, it was a hearing, an evidentiary hearing conducted over Zoom, which was interesting. And I have to say, I have to really commend the district court, the court's technology staff, clerks, everybody who participated. It actually worked very well. We didn't get bombed, and so that was really nice. But we presented evidence that there are something like 680,000 households in Wisconsin that are single-member households, and a very substantial number of those, I think it's 200 and something thousand, are people over the age of 65. So this is a not insignificant population that we're talking about in Wisconsin of people living alone. These are people who could be immunocompromised, have underlying health issues, could have the virus and not want to spread it to anybody else, but for whatever reason, they can't. They don't have a choice when it comes down to health risk of being able to have somebody witness their absentee mail-in ballots. And so that case, Geer versus Knudson, sought a lifting or a lessening of the requirement, the witness requirement. And as Sopan mentioned, we were successful collectively. The plaintiffs were successful in arguing to have that requirement at least partly lifted, relaxed a little bit. The judge who heard the case, Judge Conley, did lessen that requirement, and that was in place for about 24 hours before the Seventh Circuit cut back that restriction, put it back in place. The other case in which I'm counsel, one of the lead counsel, is called Lewis versus Knudson. That was filed around the same time that the Gear case was filed on March 26th. And that is a coalition of groups that mostly in the Milwaukee area, Voces de la Frontera, Black Leaders Organizing for Communities, Souls to the Polls, which is a group of African-American pastors in Milwaukee who are doing get out the vote work, American Federation of Teachers, Local 212, SEIU Wisconsin, Counsel. So a number of get out the vote groups, labor unions, advocacy groups. The Lewis case was the broadest of all the cases that were filed. We saw the very good work that Sopan and her team had done. We saw what they were asking for in the way of relief. And we felt that we were compelled on behalf of our plaintiffs to seek even more extensive relief than that. In particular, many of our clients and their members and constituents are lower income, members of lower income communities, African American and Latino voters in the city of Milwaukee. Historically, those communities have voted largely in person. And so some of the relief that was sought for the mail-in absentee ballots wasn't going to do as much for our clients as we wanted. Recognizing even that at the time that we filed our complaint, and we moved for a preliminary injunction shortly after that. At the time we filed our complaint and moved for our PI, already it was late March. And so the toll that COVID-19 was taking, especially on the African-American community in Milwaukee, was notable, and it was increasing dramatically. And so we felt that the only way that our clients and their members and constituents would be able to have a meaningful ability to cast their votes on April 7th, or in that election at least, would be to push the election back beyond April 7th, to postpone it. So we asked for postponement. We asked for the same type of relief in general that Sopan and her team requested, but we went beyond that, and so we asked for more extensive relief than that. As I mentioned before, there was a video hearing conducted on April 1st, and so this is the Wednesday before the election was to occur. The election was scheduled to occur and did occur on Tuesday, April 7th. We received a substantial, about a 53-page opinion, I think it was, from Judge Conley the day after, on Thursday, April 2nd. Everything was done incredibly quickly. We didn't have time for any kind of discovery, and so there was a truncated process by which the parties submitted declarations, sort of like an administrative hearing. The judge accepted those as direct testimony, and if anyone wanted to cross-examine a witness who had submitted a declaration, they could do so. As it turned out, the only witness who testified at the hearing that was cross-examined was Megan Wolf, who is the administrator of the Wisconsin Elections Commission. So she's the staff member, the nonpartisan staff member who was really in charge of the staff who administers the elections. There was an emergency appeal taken, as Sopan mentioned. We prevailed, really largely prevailed in what we wanted. We didn't get everything, but we did prevail. And Sopan mentioned a number before of the number of Wisconsin voters who were able to register to vote based on the tremendous work that they did. By our calculations, because of the extension of the deadline to receive mail-in absentee ballots from April 7th to April 13th, by our count, 140,000 Wisconsin voters were able to cast their votes. Those votes wouldn't otherwise have been counted, except for the relief that we, Sopan and her team and my co-counsel, that we all collectively obtained. So we do think that we substantially prevailed. That was taken up on appeal to the Seventh Circuit. They decided that appeal very quickly in a matter of a day. And so on late in the evening or early night on Friday, April 3rd, we had an order from the Seventh Circuit. It was a little unusual It was an unsigned order. We still don't know who is on the panel. We don't know, it doesn't say on the docket, it doesn't say on the order, so we don't know who is on the panel. An appeal was immediately taken on an emergency basis. It was an application to Justice Kavanaugh, who's our circuit justice. So we briefed that on a Sunday, and then the following Monday, and then we had the decision that came out from the U.S. Supreme Court, the full court, on late in the day, sort of midday, the day before the election. So as much as Sopen and her team had initiated the litigation several weeks before the election, I think probably in an attempt to try to ensure that what happened in Ohio didn't happen in Wisconsin. Unfortunately, we ended up being in the same position as Ohio. So that's what happened, and I'm sure we'll probably talk a little bit more prospectively about where things are going.
Thanks, Doug. Stacie?
Oh, thank you, Professor Ellis. Thank you, Doug and Sopen. I'm Stacie Rosenzweig from Holling and Cayo, and I'm one of the plaintiffs' counsels for Edwards versus Voss. Now, ours is a little different. It's sort of, our lawsuit is not being brought by any groups or advocacy organizations. It's being brought by, at this point, 14 individuals, but on behalf of a class, several subclasses of similarly situated people. And ours, again, is different because it was filed after the election, but before the results were announced. One of the outcomes, or one of the parts of Judge Conley's decision on the cases that were just discussed was that election results could not be released until the evening of April 13th to account for those late arriving ballots. I believe when the decision first came out, there could still be people returning absentee ballots at that point, and there was a concern about tampering with the results, since there were, if ballots could still be cast while results were being reported, that's not a good thing. But that injunction against releasing the results on election night remained intact despite voting not being able to occur after that point. But anyway, our lawsuit came together as I was brought into the group by one of our attorneys is Jay Urban. He's a personal injury attorney. In fact, I'm the only attorney working on this who has some background in election and political litigation. Our team is primarily, again, Jay does personal injury. Rebecca Solida does employment plaintiff side based with a bit of an emphasis on the Americans with Disabilities Act. And our other lead counsels, Joe Good and Mark Leitner, they do constitutional litigation as well as franchise litigation, other general commercial litigation. So it's an interesting team. And we are our clients are people who, for various reasons, were disenfranchised as a result of the election, despite Doug and Sopen and their team's best efforts to open voting to more people. We have several subclasses in our lawsuit. One of them are folks with disabilities that prevented them from safely going to the polls and safely voting absentee. If their absentee ballot didn't arrive, some of them were left without recourse because they either physically could not get to the polls on election day despite timely requesting a ballot, or their medical conditions or that those of people they lived with were such that if they had gone to vote on election day in Milwaukee, perhaps where 180 polling places were reduced to 5 and there were 3,000 people in and out of a polling place and 2-hour-long lines, they physically couldn't do it without substantially risking their health or even their life. Another subclass we have is we have a Voting Rights Act subclass. Our representative plaintiffs are African American Milwaukee residents who, and I'll echo what Doug said about African American voters in particular tend to vote in person on election day. There is a history of distrust of absentee and mail-in procedures excuse me. Of that, there's a distrust of absentee ballots because, when you've been faced with centuries-long disenfranchisement, and we explained in our complaint, we can that Wisconsin has been hostile to the voting rights of minority groups, especially African Americans, since its inception. Our Constitution actually only allowed the enfranchisement of Black men based on a referendum of electors, who in those cases would be white men. And it took a good while until after the Civil War for this to occur. And you know, historically, enfranchisement of minority groups has been difficult in Wisconsin. So, in any case, people who don't typically vote, who don't trust that their ballots will be counted unless they physically see them going into the machine and the number switching over, did not request an absentee ballot early on, maybe scrambled to do so at the end when they realized they couldn't go vote, or that voting in person would be difficult, or they didn't and decided to go vote in person, but then saw the lines, saw the masks, saw people in PPE, and decided again they had to make that very difficult decision between exercising a right that they and their ancestors have fought for generations, or not doing it and staying safer. And so this kind of came together in the few days after election night, where Jay, our PI counsel, was hearing from people who fit these categories and who were just upset, and they wanted to know, what can we do about this? What can we do to ensure that this never happens again? And that's where we are. The complaint came together in the weekend. It was filed on April 13th before the results were released. We wanted to make it clear that this was not something we were doing because we feared we weren't going to like the results. We have no idea who our clients would have voted for. We don't ask. They haven't offered. There's some statistical analysis of demographic groups that could provide some guesses as to where people who are in the groups that we seek to represent might fall, but we have no idea who these individuals wanted to vote for, or who these individuals will be voting for in August and in November. And so, we are looking forward. We're in the process. This complaint was just filed a couple of weeks ago. We have not had any response from any of the defendants. We sued Robin Voss, and in his capacity as the Assembly Speaker, Scott Fitzgerald in his capacity as the Majority Leader of the State Senate, the Elections Commission, its commissioners, and Megan Wolf and in her official capacity as the Administrator of the Elections Commission. Nobody has filed a responsive pleading at this point, so I can't comment as to where they're going to go. Again, I can speculate, and that could be fun, but probably ultimately not productive. And we're looking more forward to the August and November elections. There is a special election coming up in May. We don't have plaintiffs from that congressional district, and also the timing issue is a little rough on that. So we're looking to make sure that proper procedures are in place for the August and November elections to prevent this mad scramble at the end that Sopin's team and Doug's team and others tried very valiantly to make sure didn't happen, and it happened anyway. We're looking to see that, to show that it just won't happen again. And again, ours is very much a work in progress, so it's difficult to comment about where things are going or what the response might be, but that's where we are. So I'm going to turn it back to Professor Ellis, who is muted.
Yeah, well, not anymore. Zoom requires a lot of sleight of hand. There are a couple of questions in the queue, and I want to remind everyone who's listening that there is a Q&A function. Wherever your Zoom toolbar is, there's a Q&A button that you can press and ask a question. And so as folks think about their questions, let me throw out a few. First, as a general matter, given, and this is to anyone on the panel, you know, a lot of what we've talked about here is the trajectory of the federal litigation around seeking changes in the April 7th election. And certainly, Stacie, your litigation is looking forward, as you put it, to address issues now so that the August and November election don't have, you know, the same amount of panic around them. I was curious if any of you had any views on the litigation around the Wisconsin Supreme Court's decision to overrule the governor's order to postpone the election. As those of you familiar with this, and as I mentioned at the very beginning of this conversation, there are a number of cases, but certainly the litigation, in essence, between the governor and the legislature, where the court, in essence, ruled that it was not within the governor's powers under the emergency powers that he was granted under the statutes to postpone the election. I don't know if you have any views on that or comments generally in that regard.
Yeah, who wants to go first? I think we probably all do. Well, I could start. Yes. So at the very same time that the case was working, the order that was issued on April 2nd by the district court was working its way up through the Wisconsin Supreme Court, there was an emergency application for an original action that the legislature took to the Wisconsin Supreme Court. As we've experienced, Wisconsin has, for those of you who don't know, Wisconsin has a few different mechanisms by which litigants can, or cases can avoid the, they can go directly to the Wisconsin State Supreme Court, or they can jump from the circuit court up to the Supreme Court, either at the request of the parties, or the court can decide it just wants to take them. We've seen the legislature increasingly use that as a mechanism, increasingly use the Wisconsin State Supreme Court as a court of original jurisdiction. They have a beef, the legislature, they don't act like a legislature and actually legislate, instead they act like a litigant. And they run right to the Wisconsin Supreme Court and say, give us this relief. And that's exactly what they did. So they did that at the same time the order, the Seventh Circuit's order, was moving up to the U.S. Supreme Court. And it happened so quickly. I believe that the emergency application for an original action and a TRO asking, as Professor Ellis mentioned, to enjoin the governor's order that would have suspended the election. They filed that at 2:30 p.m. Central Time on the Monday before the election. We heard about it. I heard about it at about 20 minutes after 3 o'clock in the afternoon, so about 50 minutes after it was filed. At the same time I heard about it, I heard that the Supreme Court clerk, Wisconsin Supreme Court clerk, had issued an order requiring any responses, including any amicus briefs, to be filed by 3:30 p.m. So I essentially had 10 minutes to write an amicus brief. That was not going to happen. We scrambled as quickly as we could. We called the clerk's office. We sent them an email, and we said, we want to be heard on this. We want an amicus brief that we want to file. We did eventually file it, but we were told the next day that it wasn't ever considered because we didn't timely move for it and didn't file it by that 3:30 p.m. deadline. The court issued an order, and it was was it 4-2 or 5-2? I can't remember. But the court issued an order at 4:45 in the afternoon, granting the original action and granting the motion for a TRO, and then it followed up with an opinion later that day. And I'm not going to comment on the substance of the order. What I'd like to mention, though, is the process. If courts of the highest jurisdiction, whether it's a state Supreme Court or whether it's the U.S. Supreme Court, are at least in part policy-setting bodies, then having an incredibly compressed, expedited process like this, so that the court can hear only from litigants on matters that are of incredible importance to voters as a whole in the state and on important policy issues, not even allowing any amici to be heard. This is just not good, and this is not healthy for the jurisprudence in the state.
All right, thanks, Doug. I can weigh in a little bit too. And it was a 4-2 decision. Justice Kelly did not participate because he was appearing on the ballot that was going to be affected by the decision. Although he's debating coming back into pending litigation now, since that particular basis for recusal has resolved. But yeah, this was, I'll echo Doug's comments on the procedure. I've been involved in other litigation where the Supreme Court has either exercised original jurisdiction or has exercised bypass of the Court of Appeals at the legislature's behest. And this seems relatively unique to Wisconsin and relatively unique to the legislators' requests, because getting original jurisdiction in the Supreme Court under normal circumstances is nearly impossible, for good reason. It's you need to build an evidentiary record before you can have a decision made in most cases. I believe it was the ACLU recently petitioned for original jurisdiction over its lawsuit to demand that the Department of Corrections reduce its population in light of the COVID-19 issue, and the Supreme Court rejected original jurisdiction on that. So it was a bit frustrating. I wasn't involved in any litigation prior to the election, but I was watching this unfold. I was trying to counsel a friend of mine who was phone banking in New York, doing a virtual phone bank with her group in New York for the Wisconsin voting. And I probably every 3 hours I was texting her with, no, what I told you 3 hours ago is wrong now. Here's where we are. And it was frustrating and not a great way to run an election. Just regardless of which way it fell, just all of that rapid change in real time as people were trying to get out the vote was difficult. And again, Doug's team, Sopin's team, others went to heroic measures to try to avoid the very thing that ended up happening as a result of this last minute petitions and refusal to just, let's postpone this election. Like every 18 other states have postponed their elections or done something else, but we have to be special, and we saw how it turned out.
Sopin, do you want to weigh in?
Sure. Well, I would just echo Doug's comments about sort of the unusual procedural nature of that case, and echo the frustration that the timeline for response was almost as if there were no opportunity for response. We did want to file an amicus brief, and you could see in the majority opinion and the dissent that there were some arguments perhaps that the governor himself did not necessarily raise, and that would have been a perfect opportunity for an amicus brief to do something like that. So I think, that was a real sort of lost opportunity.
One of the questions our audience members has asked is if this compressed timeline was available somewhere for the general public to view. I don't know if any of you know where you could point the audience.
Well, I don't think that it's available. There are no timestamps in the docket about when things were filed, phone calls placed to the court clerk or emails sent to the court clerk. So unfortunately, I at least personally don't know of anywhere where it's reflected publicly.
Another question that I'll raise from the queue, and this one came early on in our conversation. Do we know yet whether or not there has been a spike in cases, as the question puts it, in Wisconsin on or after April 21st? If so, could those responsible for ordering the in-person election balloting on April 7th be prosecuted?
I won't comment on the criminal prosecution aspect of that question, but I will say that the most recent news reports indicate that somewhere around 40 cases in Milwaukee County, for example, including one poll workers case among them, were traced to in-person voting during the April 7th election. And I believe the Department of Health hired something like 120 contact tracers, sort of specifically to track the impact of the in-person voting on April 7th. So in terms of an uptick in the state, generally being traceable to the election, you know, I don't know if that's the case, but certainly there are particular individual cases that have been traced back to the election.
Yeah.
I would also add, go ahead, Stacie.
Thank you, Doug. The Milwaukee Department of Health has identified 40 voters and poll workers that did go in person and are now positive. The report is incomplete. We're hearing maybe the end of this week, we'll have a more complete picture of correlation versus causation. I mean, you know, to be fair, I'm not sure we're ever going to get to direct causation for any individual case, because unless these folks have had no other contact with the outside world, there could be some issues there, but we may get to, more likely than not, we may get to those sort of standards of proofs. To, you know, again, I can't speculate on, I can't talk about criminal prosecution either, but it looks like towards the end of the week we'll have a little more information on at least correlation, if not causation.
A couple quick comments. 2 points. First of all, on the last point that Stacie raised, it is very difficult when you're dealing with a sample size that's this small. For those of you who have litigated sort of complex scientific cases before that involve statistical analyses, it's pretty hard to be able to look at sample sizes like this and draw any conclusions that are, you know, that are as solid as what you'll see in a more robust kind of scientific study. There is a danger, though, too, in these studies being released. And there was a study that was study, I put quotations around that was released last week on Friday. There was an internist, I believe, at Fredert, and there were a couple of other authors, and they supposedly released a study that said that there was no increase in the incidence of COVID-19 caused by the election. Well, you get your hands on the paper and you look at it, and you know it's pretty thin. It doesn't really hold any kind of scientific water. And so I think that people are jumping to a lot of conclusions very quickly. I think what Stacie just said is exactly right. We have to be cautious about that in drawing any conclusions too quickly about whether that we'll get to be able to see that kind of an effect or not. But certainly we'll be looking for it. And I forgot what my second point is, so I'll just let it go.
Another question to throw out from the early part of the conversation. One audience member is curious about whether there are issues that may have shown up in the canvass concerning absentee ballots that were received without a postmark, or the postmarks were illegible. The questioner noted that this was a problem that we saw in the infamous Bush v. Gore election in Florida in 2000 in terms of absentee ballots. And I also want to ask a question about Bush v. Gore as well in a minute, but absentee ballot difficulty, is that an issue to your knowledge?
I can weigh in. It was. The Elections Commission, the State Elections Commission, had to meet a couple of times because Wisconsin law doesn't include a postmark requirement, and the Supreme Court didn't consider didn't consider, I guess, the realities of mail. And I'll let Doug and Sopen, who are closer to that, weigh in, but I can talk about at the end of all of this debate, it was somewhat left to the individual municipalities exactly how they were going to count postmarks that were kind of hard to read, postmarks that were fuzzy. In the city of Milwaukee, I know that there were about 390 absentee ballots that had illegible or absent postmarks. And the City of Milwaukee Elections Commission decided that they would count those. I suspect had the larger races been closer, there would have been some litigation over including those, but the margins were big, so none of the larger campaigns were going to weigh in, and I don't know, the smaller campaigns probably did not have the resources to try to parse out what that would mean. There was one county board race that was 48 votes in Milwaukee, and who knows if those 390 votes would have changed the outcome or not, but those were small races that the litigation would have been prohibitive to try to find out. So, so I know that it was kind of left up to the individual municipalities or clerks to figure out exactly what constituted a valid postmark, but I'll let Sopen and Doug weigh in on the bigger picture since they were closer to it.
Stacey's right, yeah, that it was the guidance from the WEC was that each municipality would determine whether a ballot should be counted. And, you know, I think the issue arising in and of itself sort of indicates the problem with the United States Supreme Court just sort of imposing this postmark requirement without necessarily the complete understanding of how the mailing in of ballots works in Wisconsin when you have prepaid postage. So I'll leave it at that, but it's definitely an issue.
Yeah, we have for those who don't know, Wisconsin has the most decentralized voting system in the country. We have 1,800 different jurisdictions that administer their own elections, essentially. Municipal clerks who are the ones who actually send out the ballots, receive the ballots, count the ballots. And then we've got a canvassing process after the results are certified by the municipalities. It goes to the counties, and there's a county canvassing board that has to certify the results, and then it goes to the state elections board. And there's a process at each step where if there is a question, as Stacie mentioned, there's discretion that's given to those canvassing boards about whether to count things or not. And there's a process to challenge them, and that's all part of it. And so this is just a natural part of what we typically do in Wisconsin. I am aware of one recount. There was a referendum in Racine County over some school board funding, and it was decided by 4 votes. There was a recount, and that 4-vote margin held up. And I don't know if there will be any if there will be any litigation over that, and if there is, whether the issue of the postmark will come up or not. But it was, you know, it was just an issue that was taken up as part of our regular process here.
And just as an interesting thought to throw out there and bridge to a question I want to interject, what Stacie, what you said just made me think that the underlying rationale of the per curiam opinion of the U.S. Supreme Court relied on the so-called Purcell principle of not wanting to change the rules of an election so close to an election that a court should not do that in order to avoid confusion. And yet, given this part of our conversation, we're tacitly recognizing that the court imposed a rule that is not within Wisconsin law. And that seems to be ironic to me. And as the law professor who doesn't have any clients, I can just say that. But it raises this bigger question that I'm thinking about in terms of that opinion being lumped with Bush v. Gore in terms of the sort of rush to judgment of the Supreme Court in ways that at the end of the day end up looking hyper-partisan and thus disingenuous in a way. I am throwing the kind of ticking time bomb question out there of courts imposing themselves, because at least some of the questions in the queue also wonder about court interference and on adequate grounds. So I wanted to give the panel an opportunity to comment on that if you so wish. And if not, we can move on to the other things in the queue.
Well, I can say one thing quickly. So Purcell is a consideration. Unfortunately, I think that the Supreme Court put undue influence on it, or emphasis on it. You know, there's longstanding longstanding jurisprudence that says that there is also an interest in having these issues decided. Not only do we want to make sure that they're decided, we don't want last minute changes, but we want to make sure that there's certainty before the election as well. And if that's really what we're going for, then I think leaving in place the Seventh Circuit's order, which was in place as of Friday, April 3rd, and tinkered with Judge Conley's order just a little bit, but left it largely intact. The Supreme Court really should have taken a pass on this. And this was in the form. I mean, this was in the procedural posture of an injunction hearing, an injunction that was entered. And so, there was a record there. And as was mentioned, I think Sopen mentioned in her opening comments, this all happened so fast that the court actually missed some very important facts that were in the record. Because not only did Sopen and her team and her clients seek during the hearing, as Justice Ginsburg mentioned, the kind of relief that the applicants to the Supreme Court said, was never sought. We actually pled that in our complaint, and we sought it in our injunction motion. So it's a little curious to me that the court was putting so much emphasis on Purcell when I'm not really sure that they were advancing the principles that it was designed to protect.
And I think that's right. And I also think, too, that a part of the challenge here, and at least what concerns me, just to opine for 30 seconds, is the notion that both with the U.S. Supreme Court and the Wisconsin Supreme Court, the concerns raised by the dissent in the Supreme Court case that, what about the voters and what about the uniqueness of the situation and the risks, certainly in terms of the Supreme Court's 14th Amendment jurisprudence. There is an underlying standard of balancing the concerns of the state with the concerns of the voters. And speaking for myself, I would say that that kind of consideration, for it to not factor in the majority decisions here, is disturbing. Now that I've gotten my thought out of the way, a couple of the questions asked about the state Supreme Court and how one questioner asked how the new composition of the Wisconsin Supreme Court might affect voting rights decisions going forward. Another question asks for the panel to opine more about the court's inclination to expedite and be a court of original jurisdiction, as it was put earlier, concerning these matters, and in essence, what can be done about it. So any views on those issues around the state Supreme Court? Don't all talk at once.
In terms of the how the new composition of the Wisconsin Supreme Court will change voting rights decisions going forward, obviously it's hard to predict anything, but if the court continues to split the way that it has sort of in the past, I don't know that we'll see new majority opinions on that front, but there are no guarantees.
I have one thought. Justice Hagedorn, who was elected a year ago, I think has shown a different tendency that's a departure from his colleagues on that court, who are perceived as being the conservative justices on the court. He seems to have a little bit more of a focus on and I'll just say respect for the lower courts. Of course, he was a Court of Appeals judge before he went on the Supreme Court. And we saw this happen in what's been referred to as the voter purge litigation that still is ongoing, but that flared up in the fall last year. I was counsel at the League of Women Voters in that. And there was early on in December, there was a petition for bypass that was filed by the Wisconsin Institute for Law and Liberty. The plaintiff in that case, it was actually seeking to enforce the deactivation of 230,000 registered voters from the rolls. And Will sought to, they petitioned the Wisconsin Supreme Court for bypass. That's another one of these mechanisms where you just jump from the circuit court right to the state Supreme Court. And Justice Hagedorn actually joined with the two justices who were perceived as being, the liberal wing of the court. And it wasn't explained why they denied that petition to bypass, but those of us who thought about it thought that Justice Hagedorn probably recognized that there is a process and you need to follow that process. And so I think that with Judge Krosky coming on the court, I think that shifts the dynamic a little bit, and I think we might see a little bit more reluctance after August 1st for this court to entertain original jurisdiction as often as it has in the past.
Well, we are about at our hour, and I want to acknowledge that the time of all our panelists has been valuable, and given the ongoing litigation, you all have a lot to do, and we certainly would hope that that going forward, these lessons that we see at this time would be learned by the courts and by the litigators, and we can ultimately work to free and fair and safe elections for the people of Wisconsin. And hopefully this can be a lesson for people nationwide in terms of the right to vote across the United States. I want to thank the ACS. In addition to thanking our panelists, I want to thank the ACS Madison Lawyer Chapter and the Milwaukee Lawyer Chapter for organizing us today, and ACS, the national office, for helping support the infrastructure here. I'm sorry we couldn't get to every question that was asked in the chat, but we are at our time, and I promise to respect our speakers' time. So thank you all very much. I don't know if there's anything else I need to do to close. Jake?
Yes. Hello, everyone. My name is Jake Mazetas. I use he, him, his pronouns. I'm the Lawyer Chapter Fellow here at ACS. I wanted to thank, on behalf of ACS, on behalf of Craig Massantuno, the chair of the ACS Milwaukee Lawyer Chapter, Jeff Mandel, the chair of the ACS Madison Lawyer Chapter, as Professor Ellis said, all of our panelists for joining today and for your continued leadership at ACS. I wanted to just point out a few upcoming events. We've got a panel this upcoming Thursday with Professor Ellis and with Jeff of the ACS Madison Lawyer Chapter, looking at some of these election rulings and what they mean more generally for voting access and for voting rights kind of in Wisconsin and in the United States more generally. And then also please feel free to check out our events at events.acslaw.org. We've got a lot of events hosted by a number of chapters across the nation, and one of the, I won't say advantages, but one of the kind of nice things about hosting a lot of virtual events is that folks can log in wherever they are. So if you see something interesting, even if it's not for a chapter that you're perhaps nominally associated with, please feel free to join and to listen in. And with that all, I just want to say thank you again to everyone, and I hope everyone, both panelists and attendees, have a great day. Thanks all.